making a lot of people, even close watchers like yourself, ask where lie the truth in all of this. Yesterday, he also brought another, picture and comment saying that they have come to him to say, hey, just calm down and let's see how this works out. The way this is going, if we go by Section 308, which we have all agreed now by you, saying that he can also waive his immunity, and we've also seen that that the EFCC can go ahead and investigate. If you were to come in as a legal counsel here, maybe for the bank, what would be that thing you'll be saying to the bank to clear its name?
Well, the bank doesn't have much choice because the act, that EFCC act, says that upon being served with that freezing order, the bank shall comply by supplying information about the transactions in that account to the EFCC chairman or any person authorized by him. So there is really no choice on behalf of the bank. And that's what Zenith Bank has done. They have cooperated with EFCC by, first of all, stopping all outward payments from that account, and then informing Governor Fayose that this is what we have done based on the request or the order of EFCC. So Fayose, if he wants, and he had threatened, he can go to court to challenge what EFCC or Zenith Bank has done to his account. But Zenith Bank, in my own view, they have done the needful.
Coming back to
the other aspect of that Zenith Bank funded his campaign or contributed money, for me, it's neither here nor there. That is a matter that is a matter of details by the EFCC. They will deal with that one. The most important thing is that they found a trail. It's a trail of movement of money from the treasury of Nigerian government to an individual account. And they have done what is required. The owners of the account have not been found guilty. They have not been said they stole the money. It is still subject to investigation. They may be cleared. The money may be returned to them.
All right, well, we'll take a quick break, but we'll be back and continue our focus on this one. Join us again. Welcome back to Sunrise Daily, focusing on continuing our conversation with Mr. Emeka Ngige, SAN, on the activities of the EFCC and the state governor. But then the question that a number of people seem to be asking here is that, so then some actually thought that there had been a previous court ruling that the EFCC cannot freeze a state government's account. Is that correct?
Well, I'm not aware of such ruling. I'm just hearing it for the first time. But if there's such ruling, I don't think it is by the Apex Court, that is the Supreme Court. Even though if it is High Court, it's still a binding decision. But I'm not familiar, I've not come across such a case.
Okay, so if the ex parte motion is supposed to last for, say, 2 weeks, does that mean that after that 2 weeks, because his tenure, the governor's tenure doesn't lapse, if it lasts for, say, if he's got a year more or a year and a half, what is the EFCC's intention then? Can they sufficiently then take what they've seen in 2 weeks and then as evidence in court and then unfreeze the account, or what? They keep freezing the account, renewing the order every 2 weeks?
Thank you. Well, those who have been mentioning 2 weeks, they are mixing civil procedure with criminal procedure. It is in civil procedure, particularly at the Federal High Court, that when an order ex parte is obtained, that order shall lapse after 14 days unless there is a renewal of that order by the court. That is contained in the Federal High Court Civil Procedure Rules of 2009. But in terms of criminal proceedings or a matter preceding criminal proceeding, as in the instant case, there is no time limit. The EFCC Act did not provide any time limit for the duration of the freezing order. So those who were mentioning it, I heard some of my colleagues mentioning 14 days. They are mixing civil procedure and criminal procedure.
Is it the EFCC Act that is supposed to state the duration that the ex parte order can last, or the court?
The court, if you know, there in the EFCC Act, there is a format, Form B, in that Act, which gives the format of which the order shall be served on the bank. If you look at that Form B, there is no provision made there for duration. All that is said is that you should suspend further transactions in this account pending investigation. It didn't say within 14 days to last or after 14 days. No, pending investigation.
You know, this is very tricky here when we talk about the investigation. First, let's deal with the rest. Freezing of the account so that nothing, untoward happens to the rest. For some other financial experts, they say the transaction details or history with the bank is enough rest for anyone to hold on to.
Well, it will be dangerous because if you start locking the stable after the horse has bolted, it becomes an exercise in futility. You have seen money that is suspected to have been taken out from government treasury, and you allow the operators of that account to take the money away because